today's program, which is sponsored by our Torts and Litigation Practice Group. As you probably saw in our program description, we're going to try to have some fun today with a game show style presentation, and we'll be using that polling feature on GoToWebinar. So take a look for that, and we're going to use that polling feature throughout. So we want you to play along, as they say. And actually, we'll be raffling off a gift card to one lucky winner. So I'll talk more about that toward the end of the program. Joining me today, I should say, are Rick Simchek and Alana Buford-Kamerman from our Torts and Litigation Practice Group. They're going to serve as our game show hosts, and we're going to examine four key areas of general liability: premises liability, evidence in litigation, offers of judgment, and something that's an interesting wrinkle, waivers, and whether waivers carry any weight in the state of Michigan. So before we get started, I'd like to take just a couple of moments to provide you with some background about today's speakers and our law firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest firms with approximately 150 attorneys. We have 7 offices in Michigan, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our Tort and Litigation Practice Group is comprised of attorneys from across the Midwest who focus their practice on various aspects of general liability, retail liability, premises liability, dram shop law, food liability, and other areas of litigation. They routinely defend cases involving retailers, food service and hospitality establishments, commercial property owners, and other businesses that are insured by some of the world's leading insurance providers. And so having said that, I'm going to now turn over and introduce our speakers formally. Start with Rick Simchek. He's been practicing law for 42 years, and he manages a diverse litigation practice that includes premises liability, insurance coverage, motor vehicle claims, title insurance, and banking law. A member of our Bloomfield Hills office, Rick works closely with clients that are self-insured and policy holders of insurance carriers that we are panel counsel for, and those matters are often complex and high exposure matters. He's a member of the Michigan and Genesee County Bar Associations and DRI, which is formerly known as the Defense Research Institute. Alana Buford-Kamerman is a member of the firm's Lansing office. We recently moved our East Lansing office to Lansing, so they're still getting settled in there. And then Alana serves as co-leader of Plunkett Cooney's Diversity and Inclusion Committee, and she's a member of our Torts and Litigation Practice Group. She routinely defends litigants involved in a variety of matters, including claims involving premises and general liability, as well as municipal disputes. Now for just a couple housekeeping notes, and we're going to get this game up and going. As I previously mentioned, you will have a chance to respond to a number of poll questions today. And when those polls appear on your screen, simply click on the answer you think is correct, and you don't have to worry about whether you get it right or not, because your responses will be anonymous, and the reveals will only indicate the percentage of attendees who thought any one answer was correct. So we will review all of that as we go along. And as I mentioned, our questions and answers section, we always want to leave a little time at the end in case you have questions beyond what we cover or akin, and hopefully they are akin to what the topics are. We'll try our best to answer those. So our questions widget is part of your GoToWebinar display. So find that if you can, and you can ask questions as we go along, but we'll reserve those to the end as we get through our materials. Finally, I want to mention that today's session is being recorded, and we'll have that recording available on our event page, which is located on Plunkett Cooney's website. And for those that don't know the web address, it's plunkettcooney.com. Go ahead and feel free to share that page with others that maybe colleagues you think would enjoy hearing today's program. So thanks again on behalf of Plunkett Cooney for being here. It's a little earlier than normal. We usually do these during the lunch hour, but we're happy to be here and have a little fun today, I think. So now it's time to play our game on. And Rick, I think you're going to lead off today, so go ahead and take it away.
We'll lead off. Thanks, John. Today, because we are in an election year, we thought it would be a little more fun to make this a little bit more interactive and have this webinar designed so that the audience could participate by voting for what they think the right answer is as it appears on the screen. So we're going to address 4 areas of the law premises liability, offers of judgment, evidence, social host liability, and waiver. Some of those are connected, of course, but the idea is to give you as the audience a chance to pick the answer in areas of the law that are maybe obscure or maybe not so obscure, but where common sense doesn't necessarily meet the law. So with that, we're going to ask you to concentrate and compete. So let's get started.
Well, let's get started with a practice question, just so everybody can get used to the functionality of our polling feature here. So first and foremost, let's do a simple question. Who's your favorite celebrity? Tom Hanks, Oprah Winfrey, Taylor Swift, or none of the above? Go ahead and lock in your answers.
This is our chance to test the technology before we get deeply into the seminar or the webinar. But
very interesting results so far. I'll post these here in just one more second. Go ahead and finish up your voting. And I'm going to close that poll. Yeah. Here we go.
None of the above.
Wow.
That's awesome.
Voted for Oprah.
I know, right?
Oprah.
Well, that's the singularly most surprising thing there. Not everybody likes Oprah.
I did too.
Oh well. Well, John, I think the technology's working.
Yeah.
Well, I think it too. It shows we have a lot to learn. All right.
All right.
Well, let's jump into the first segment here.
Yes. There we are. Our first section, premises liability. When we talk about premises liability, the concept is it's when a condition of the property is what's alleged to have caused the harm. In our first question, we're going to talk about the status of the person who is making the claim. Suggest for a moment that your best friend is coming over to visit at your new apartment. As he comes in, he does a face plant and trips over the threshold of the new apartment, fracturing his nose. When he turns around to sue you, what's most important is what status does he have? Who is he and what duties are owed to him?
So the legal question here, as you see on your screen, is a social guest is treated as a blank. Is it an invitee, a licensee, a trespasser, or none of the above? You know, I think the real question, quite honestly, is that still your best friend? After they but we'll see.
And the selection in front of you, invitee, licensee, trespasser, none of the above, they're in descending order of duties. So we'll see exactly how much we understand about what duties are owed to someone who's over for a visit.
Yeah, how high do they make it on the ladder?
Okay, everybody has locked in their vote. I'm going to close the poll and share it. Here we go.
Well, invitee won the poll, but the correct answer is licensee. Number two, only 11% of our folks got that, but here's the difference. Social guests are not there for the benefit of either themselves necessarily or their host, the premises owner. Because of that distinction, they are not an invitee. A business invitee, like a customer in a store, a patron in a restaurant, is owed a higher duty than a licensee who's simply a friend coming over to see you. So that's where the distinction comes in, and that's where your friend or ex-friend who's just over for a visit is simply a licensee. He accepts or assumes the ordinary risks associated with their visit. And so, moving along to a second concern, let's talk about whether the open and obvious defense applies in a certain instance. As we know, open and obvious is a defense that arises out of whether the condition of the property is something that would have been noticed or should have been noticed more properly on casual inspection. But we added a little wrinkle to this question. What if the customer is visually impaired and slips on a puddle of water in the restroom of a fast food restaurant? does the impairment change the duty owed?
All right. So your question is, does the open and obvious doctrine apply to the impaired? It's either yes, no, or probably what sounds like the most lawyerly answer, it depends. Let's see. I think a lot of people are probably really struggling over this one, but what do you think, Rick?
The difficulty here that's presented is, number one, this is one of those situations where hard questions or hard issues make bad law. Hard cases make bad law. Does one ignore the fact that this is someone who couldn't see it if it was there and was open and obvious, or does that really matter?
Does it? Well, John, how are the polls coming?
Here comes the answer.
Yes, no, 13%, 88%, it depends. Interestingly enough, under the case law, the concern is not whether the individual is impaired, but whether the condition truly was open and obvious. Because the courts apply open and obvious on an objective, reasonable person basis, the courts do not pay attention or give any consideration to the fact that this individual would not have seen the open and obvious danger. The case is unpublished. It's Robinson versus the state of Tyler. It goes back to 2003, but it does establish in an unpublished and therefore not controlling, but certainly instructive way, that it doesn't matter whether the person could have seen it. It matters whether a reasonable person could have seen it. If a reasonable person would have noticed the puddle of water, then the impaired person cannot recover. That's the law.
Yeah, I think a lot of people were surprised by that one. So what's our next question here, Rick?
Next question goes to the issue of notice in premises liability. The law provides that not only does the premises owner have to have notice of the dangerous condition, but also has to have a reasonable time in which to react. And reasonable can vary from case to case, time to time, place to place.
Mm-hmm.
And what's really reasonable? In this circumstance, how long does a premises owner have to correct the defect? Let's assume for a moment that we have a toddler who, in his mother's shopping cart, unscrews the cap to the detergent and spills it on the grocery store floor. Someone comes by, slips and falls. Because a third party, in this case the infant, created the defect, how long does the detergent have to be on the floor before the store has constructive notice? And constructive notice is proof that the product was on the floor, the defect was present long enough for the landowner or the premises owner to recognize it and have the opportunity to correct it.
All right, so our question here is, how long does the premises owner have to correct a defect caused by a third party on their premises? A reasonable time, B, 10 minutes, C, a considerable period of time, or D, not enough time?
In this instance, again, the important point is not merely that there's a defect, but that it's also present for a period of time that allows the premises owner to correct it. That's really the key here. And the key with that is, how do you gauge that amount of time? What's enough? So we have reasonable amount of time, 89%, 10 minutes, 0, considerable period of time, 11%, or not enough time. Everybody virtually got this right.
All right.
What's really interesting, though, is that 11% said a considerable period of time. There is actually a federal court case where the judge didn't use the term reasonable time. He said a considerable period of time. So really, we almost have two correct answers, and everybody got one of the two correct answers.
Awesome. Awesome. Well, I think that takes us right into our next segment here, offers of judgment. So just to give a little background for you folks at home, defining what is an offer of judgment. Now, under the Federal Rule of Civil Procedure 68, an offer of judgment is where a defending party in writing makes an offer for a specific amount of money and an unconditional offer that's filed with the court to the other party that says, hey, we'll settle this dispute, we'll let you enter a judgment against us for this amount of money, point blank. Now, like I said, that's in the federal court, Federal Rule of Civil Procedure 68. But what about Michigan? I think that here takes us to our first question.
In Michigan, can offers of judgment be made by which party? Defendants, any party, plaintiffs only, or Michigan does not permit offers of judgment?
I think it's actually really interesting here because I think some people are going to be wondering, well, why would you ever make an offer of judgment if that's even possible here in Michigan?
Well, this is really one of those things that lends itself to the idea of strategy. What is the way to put the opposing party on guard because of the potential consequences of what offers of judgment are?
Yeah.
And the question is, does Michigan really approve of that because of the potential sanctions and the difficulty it presents, even in negotiations or in settlement of cases, which is always encouraged?
So let's see what the audience had to say. John?
Yeah, I think our folks are struggling with this. Some folks sat this one out, so only 67% voted on this one.
That's all right. We'll give you the answer here. So the poll says 67%. Most of you guys actually got it right. Any party in Michigan can make an offer of judgment. Now this here is a slight but significant distinction from the federal rule, actually. Like I said, in the federal rule, only a defending party, a defendant, can actually make an offer of judgment. But in Michigan, any party actually can. So this does tell you as well that Michigan does have an offer of judgment rule. It's located at Michigan Court Rule 2.405. And that then, as Rick and I were previously discussing then, well, why would a party, any party in this instance, make an offer of judgment? And it's simply for strategic negotiation and pressuring parties with the potential or possibility of being on the bad end of having to pay sanctions. So this then begs the question, well, how do we recover sanctions from another party if that's what we're hoping to accomplish? So what's our next question?
In this instance, we're talking about the sanctions, which are really the teeth that go into this tactic of offer of judgment. Offer of judgment sanctions can be recovered from a party if, one, the rejecting party position is not improved above adjusted verdict. Whether the party made a less favorable offer within 42 days of trial, both A and B, or none of the above.
So these based on one of these answers at least, that there has to be some specific types of conditions that have to be met in order to get those potential sanctions. So.
And again, this is a matter of strategy, and one has to be very sophisticated about this because adjusted verdict is not an easy concept necessarily in every case.
No, not necessarily. And I will say the offer of judgment rule does have a specific definition of that. Here in Michigan, the adjusted verdict is under the offer of judgment rule is defined under subsection D of that rule 2.405. And it defines the adjusted verdict as the literal verdict that you get at trial, in addition to the cost from the date of the complaint that was filed up until the date of the most controlling offer, as well as any interest that's included on top of the verdict.
And we have results.
We do. Well, look at that. Most people, it was really split between A and C. So the correct answer here is C. So in a way, everybody kind of got it right. So let's break this down, starting with A. So we just defined what the average verdict is. And specifically, in order for a party that rejects an offer of judgment made by its opposing counsel or its opposing party, they have to improve their position, meaning their recovery has to be more if you're a plaintiff than the adjusted verdict, or if you're a defendant, and you reject a plaintiff's offer, well, then the verdict has to be less than the proposed offer of judgment. Now, by that same token, as we've been mentioning throughout this segment, the offer of judgment is kind of a double-edged sword, and the court rule takes note of this. Specifically, regarding answer option B, on the flip side of making an offer, the party making the offer has to be more and more careful the closer we get to trial, because under subsection B of 2.405, if a party who makes an offer within 6 weeks of trial, 42 days, and that offer was unreasonably low or unreasonably high to indicate that it was made in bad faith, then that party making the offer might actually get sanctioned. So that is to say, the courts don't look favorably upon if a defendant tries to lowball and significantly undervalues a case. By that same token, if a plaintiff attempts to shoot for the moon and hopefully land among the stars and overshoot their offer. So then let's talk about, well, how much do we have to improve our position here when we're making offers of judgment?
And that's our next question.
That sure is. All right.
The issue here is to recover an offer of judgment sanction, the party must improve its position by at least what percentage? So low as 0.01, so low as 1%, so low as 10%, or none of the above. So there's a real broad spectrum here, even though it's very much at the low end of the spectrum between 0.01 and 0.10, or 10%.
Yeah, and so this here too even echoes a little bit what we have in Michigan called case evaluation, when that's where a panel of 3 attorneys look at a case, look at the brief submitted by the 2 parties, and they say, hey, we think this case should settle for X amount. And under the case evaluation rule, parties have to, if they reject a case evaluation award, have to improve their position at the time of trial by at least 10% in order for sanctions to apply. Now, is that the case here with offers of judgment? I think we're going to see here in a few moments. How are those polls looking, John?
They are in. Here we go.
All right. Well, interestingly enough, a lot of people said 1%. A lot of people said 10% as well, and I think that's coming from our people who know about case evaluation. But actually, the answer here, the most correct answer, is 0.01. And that's really to illustrate the fact that Michigan's offer of judgment rule only says that a party has to improve their position. There's no specific percentage that's required in order to recover sanctions from an opposing party if the offer of judgment sanction conditions, the proper conditions now, mind you, apply. Now, to that effect, though, there's also another caveat. Offer of judgment sanctions, though, aren't necessarily guaranteed under the Michigan court rule, whereas in case evaluation, they are mandatory. Here, under the offer of judgment rule, the courts have discretion in determining whether or not to apply the offer of judgment sanction. So that is to say, maybe a defendant offered $50,000 in an offer of judgment, the plaintiff rejected, and the verdict came out just above that 50, or maybe say 51,000 or so. Well, or maybe just under at 49,000, and they didn't really improve their position so much. Well, the court can say, well, that was pretty close. It seemed like it was made in good faith, and it seemed like you had a good evaluation of your case. We're going to make it a wash and not apply the sanctions here under the court rule. So, again, it's about being very strategic and making it a competitive offer and making sure you time it right in order to obtain those sanctions if that's what you're looking for under the offers of judgment rule here in Michigan specifically. So speaking of trial, I think our next segment here is evidence.
In discussing evidence, and this is a very apt slide here with the jigsaw puzzle and the evidence sticking out like a sore thumb. The issue is with evidence, what can you present at trial? That's always the ultimate question. it's not what we know, it's what we can prove. And we prove everything with evidence. And even with all the rules of evidence that we have, both Michigan rules and federal rules of evidence, there's still room for case law to fill in some of the holes and the blanks in the rules of evidence. For example, we have a dram shop action, an action by a person who was injured by a person who was intoxicated while drinking at an establishment. Often in cases like that, the key witnesses are the employees who served the allegedly intoxicated person and who will testify as to whether they appeared visibly intoxicated, whether they slurred, whether they slipped, stumbled. So, but as often happens, the employees in establishments like bars and restaurants and certain stores rarely stay in one place of employment for very long.
True.
And so by the time one finds an employee who may have served the allegedly intoxicated person, and you take the deposition, the employee is often no longer an employee.
So our question here is a deposition by a former bar employee, A, inadmissible hearsay, B, admissible as a party admission, C, depends on whether he or she is unavailable to testify, or D, none of the above? You know, this is a really interesting segment or question here, because I know a lot of clients really worry about this. I mean, retailers, restaurateurs, all of those types of businesses have people who are businesses that have a lot of turnover, especially retailers in the Christmas season. Right.
And the issue becomes whether this bar employee is an agent so that you can get around the hearsay rule by saying it's an admission by an agent, by a party employee. And that becomes the means by which someone argues that it is admissible.
Yeah, and that's really scary because you don't have so much as control or exposure to that potential former employee.
But the results have come in, and the results are inadmissible hearsay 0, admissible as party admission 60%, depends on whether she's unavailable to testify 20%, none of the above. In fact, according to Shields versus Red Oak, Michigan Supreme Court decision of 1989, the deposition is in fact inadmissible hearsay because the witness is now a former employee. The statements made in the deposition after no longer being employed are not considered to be admissions. So therefore, they would be considered inadmissible hearsay under that rule. So in this instance, unfortunately, we didn't quite catch that one.
Yeah.
We didn't quite catch that one. But we're ready to go on to the next one and talk about affidavits. As we all know, in motions for summary judgment, very often we need affidavits to supplement the record and to get them from employees, expert witnesses, doctors, eyewitnesses. We have to have affidavits to present as evidence under oath, generally, to make a motion for summary disposition. In this instance, we have an unsworn, unsigned affidavit by an expert. Can it be offered as evidence in support of a motion for summary judgment?
Oh, specifically, it's simple. It's true. Yes, the court can consider it. False, the court can't consider it. Or C, my favorite, the most lawyerly answer it always sounds like to me, it depends. Oh man, these are always so fun to see once you put in a dispositive motion.
Well, and the question becomes, is it a simple answer or is it the counterintuitive answer? Or does it just simply depend? And considering how critical and how important motion practice is nowadays, this becomes pretty significant.
Yeah, it's always a significant issue.
Trial court can consider this ruling on a motion true, 50%, false, 17%, 33%, it depends. Interestingly enough, the 50% wins this time. In fact, Gorman versus American Honda, the trial court has the discretion to consider an unsigned, unsworn affidavit. I found this very surprising.
Oh, yeah.
When we think about the number of times we've been told that our evidence is not adequate, even when we have signed sworn affidavits, even when we have photograph and video evidence, and still judges find question of fact. And to say that they have this kind of discretion in terms of what evidence they'll consider, even if it's not sworn evidence, was quite surprising to me.
Oh.
And surprising to me that so many people caught this and got it right.
Yeah, well, I think that means we have some sophisticated clients here. All right, so that means now we move on to the next segment here, pre-injury waivers. And I know a lot of people are always interested in these because, I mean, how nice would it be to say a complaint filed, but nope, you can't recover anything because you've already signed away all the liability against us. That just sounds like a picture-perfect type of lawsuit for most people. So let's see if we can even consider that here in the state of Michigan. So our first question.
Does Michigan permit parties to enter into pre-injury waivers? And when we're talking about waivers, we're talking about essentially a release that you sign before you engage in the activity. So can you actually give up your right to sue before you've got anything to sue for? No, yes, first two choices. Yes, but only for injuries, not death. Yes, but only if the agreement doesn't include a jury trial waiver. So with those kinds of details, what's the right answer?
We've got a number of people still voting here. They're thinking about this one, so I'm going to give it just a little longer.
Let's go. Think hard. I would.
Well, this is a fluctuating area of the law of late, and a lot of people have had experiences under what we'll now call the old law, and will, I think, be somewhat surprised by what the new law says.
Yeah. So let's see what the people said. Here it is. So 29% of people said no. By that same account, 29% of people said yes, with the remainder saying yes, but only for injuries, not death. Well, actually, here in Michigan, pre-injury waivers or release of claims prior to your injury are allowed for both injury or death. And that's confirmed in the Michigan Court of Appeals case, Gara versus Woodbridge Tavern in 1997. So generally, Michigan law applies, though, the same type of principles it would to any other contract when looking at these types of waivers. Parties aren't limited for the types of injuries, and they're also allowed to even waive the right to a trial, specifically, too, even if an agreement does include a binding arbitration agreement as well. So there's actually a lot of hope here in this regard. So moving on, though.
I was going to say, Alana, I should be careful before I do that bungee jump then, is what you're saying.
Oh, see, my husband, he had to agree to take that off his bucket list before he could even marry me. I was like, that's a non-negotiable for me. I don't do bungee jumping, skydiving, any of that type of stuff. No, sorry. So now that we know that Michigan does allow pre-injury waivers for either injury or death in Michigan, are there any exceptions? Are there any type of agreements under this that can't apply or that aren't allowed?
Okay, and the question then becomes, which is not a recognized exception? What isn't an exception to the enforcement of pre-injury waivers? Conduct amounting to gross negligence or wanton misconduct, employer-employee vicarious liability, whether vicarious liability can be released before the event happens, a landlord's statutory duties to a tenant, are these duties non-delegable or are they delegable or are they releasable? And lastly, parents signing waivers on behalf of children. Like all those times we used to go on field trips at good old St. Anne's, and you'd have to get that signed waiver from your mom and dad. Otherwise, you couldn't get on the bus and go to Greenfield Village.
Oh.
So, and believe me, Sister Richard Michael would make sure that waiver was signed.
Well, I'm sure both parents do. They think about that, and they're like, anything to get the kids to have fun. Give me some moments of peace, maybe. Although I do think some people might be thinking about a few of the other options here. How are the polls looking, John?
I just wrapped it up and shared it, so it should be popping up on your screen.
And there it is. So 50% of people said that conduct amounting to gross negligent or wanton misconduct. 50%, that's interesting. 17% split through the remainder is split 17% evenly for the other options: employer-employee vicarious liability, landlord statutory duties to a tenant, and parent signing waivers on behalf of children. The correct answer is actually D. So in Michigan, what's interesting is this is where an interesting example of our checks and balances system here in Michigan. So back in 2010, in the case Woodman versus Kara LLC, dated 2010, the Michigan Supreme Court actually determined that Michigan common law did not permit any parent to sign on behalf of their children any pre-injury waivers. So all those time Rick was going to Greenfield Village, those papers weren't worth anything actually. And so in response, then in the following couple of years, about 2012, the Michigan State Congress passed the law MCL 700.5109, which authorizes the parents to have the authority to sign a pre-injury release waiver on behalf of their child, solely though for things inherent risk to social or physical activities, recreational activities, such as a sport, camping, maybe trampolines, things of that nature. And that's to say then, conversely though, that all of the other three options there are exceptions to the Michigan pre-injury waiver law under common law. All those exceptions apply. So, what would the law be without the exceptions specifically, right? Now, unfortunately, we don't have time to go into each and every one here, but we can stop and think, if we can get a pre-injury waiver, well then what is it we have to exchange between the two parties in order for that agreement to be valid? Which takes us into our next question.
Which is not an adequate consideration for entering into a pre-injury waiver? Mere money, answer A, allowing the person to participate in the activity. So the exchange of the release for the opportunity to be able to zip line down the mountain, completing a pre-existing legal obligation, or none of the above.
That takes us back to 1L year of law school, specifically talking about consideration. If anybody's wondering what that is, that's just simply saying, what do I get out of making this promise to the other party? What do you have to give to another person in order for a pre-injury waiver to be valid? I think a lot of people are hoping it's just money, but I wish life was so simple, right? If we could only have to exchange hands, then that would be it. But where would the law be if that's all we could do?
If that's all there was. That's all there was.
All right, we'll give you guys a few seconds here to lock in your answers.
And the difficulty here is how do you arrange for that consideration to be expressed so that people understand that there is a trade for trade here.
Exactly. Well, the polls are, again, man, it's interesting to see these results come in because they get split pretty evenly across. So the first two options are split 17% to 17% monetary payment and allowing a person to participate in activities, whereas the other two options are split 33 to 33%, completing a pre-existing legal obligation, or none of the above. The correct answer here is C, just fulfilling a pre-existing legal obligation. So that is to say that if you already have a legal duty to another party, say to act reasonable or not be negligent, essentially, that alone is not enough to make a pre-injury waiver valid. Now, that's not to say that the consideration has to be extremely exorbitant. Under Michigan law case Dobler versus Rogue, That's the Michigan Supreme Court case, actually issued back in 1922. Consideration can be fairly small in order to make any contract valid. In regards to pre-injury waivers, the court looked at this back in 1990 in the case Patrick versus 6600 Limited, and there the court held that a person playing in a softball game, in a softball league, which they probably weren't good at if you look at the back of the case, because the plaintiff here was a middle-aged man here. That alone was enough to make the pre-injury waiver valid. Just playing, having the opportunity to sit on the bench and play in the softball game was enough. With that, I think we're almost done here. We're getting into our last section.
Yes, I think we're about to start the section on social host liability. Boy, we must have dredged the archives for this.
I was going to say, though, I love all this.
Rick, is that you in the background there, Rick? I can't tell.
Just the pocket square. Look, social host liability is a consideration for all, well, used to be a more popular consideration because we used to be able to be social and to host things.
Yeah.
Nowadays, we don't do that quite so much. And even when such events do happen, we now have some overwhelming risks. But be that as it may, some of us still participate, and some people participate very actively. So what happens? What happens when you have a graduation party or a Christmas party?
Or a barbecue
or a
Christmas party, all
birthday party, and alcohol is available and minors partake, what can happen? Even when adults partake.
Yeah. So our question is, a host who knowingly provides alcohol to an individual is liable for damages caused by the individual if A, the individual was visibly drunk, B, the individual did not have auto insurance, C, the individual was known to have problems with alcohol, or D, the individual was a minor. I will say I am very excited for those days that we can get back to a lot of social gatherings and everything. I've got a new house I really want to show off to people.
Well, it's, we live in what people have called interesting times.
Yes.
But this is a question that still transcends because people are still getting married.
Yes,
there's still weddings.
Baby
still
showers.
Baby showers, wedding showers. So there's still get-togethers. There's still alcohol, and people are still imbibing. So this is still a risk.
All right. Looks like our polls are closing.
Must be. And the results are: individual was visibly drunk, 83%. Auto insurance, 0. Individual was known to have problems with alcohol, 0. Individual was a minor. In fact, the correct answer is that the individual was a minor. The responsibilities of a social host are not quite the same as those of a dram shop owner or a bar owner or a restaurant owner. Here, the issue turns on actually a breach of the law because providing alcohol to a minor breaks the law. The minor drinking is a violation of the law. And so both of those things can be the occasion of liability for the social host who permits that to happen. So that's why the last answer, individual is a minor, which 17% of our audience got, is correct. Now, in social host liability situations, what can be recovered? Here we have lost wages, medical expenses, pain and suffering, or all of the above. The question is, if you have someone who was a victim of a person who became intoxicated at your party, and that person sues the host, what can he recover? One or one of these things, two of these things, three of these things, or all these things.
It'll be interesting what people say. I know being a new homeowner, I think about all of these types of things nowadays. Someone's coming onto my property. Okay, well, here's what we do. This is We're not going to do anything. We're just going to sit here and be nice and admire how nice things are.
Well, and the thing is, we take so many things from, other areas of the law and overlay them on here on what's a general liability homeowners insurance policy kind of question,
Oh, yeah.
and see whether that influences us. John, how are we doing on results?
I am sharing them now. We had some people sit this one out there. It didn't look like they were too confident. So here we go.
No. Well, the people who were confident were right.
Yeah.
It is all of the above. It is 100%. There are no limitations, essentially, on what one can recover in this kind of circumstance. We're getting better as we go along.
It's true. It's true. Man.
We're getting better as we go along.
That's our first 100%.
Yeah.
Yeah. I think we got one more question, John.
Yeah. Here it comes. So a host can assert which of the following affirmative defenses. Is it A, that minor looked to be of age? B, the minor passed the sobriety test before leaving the party? C, the minor left the party without notice to the host? Or D, the minor presented a fake ID to the host? Oh man. See, now thinking about this too, I think about my sister. She just entered college, and I told her to make sure she doesn't participate in such activities.
Oh, but one thing to say, one thing to acknowledge, another thing to do.
Yeah.
But in this instance, in a lot of ways, those all seem like reasonable defenses.
They do. They really do. Well.
And the answers are: hosts can assert which of the following defenses? 0 for the 21, 17% for the sobriety test, 0 for the minor left the party, 83% for the minor presented a fake ID to the host, and in fact, that is the correct answer. Essentially, by presenting a fake ID, the minor's engaging in fraud. The fraudulent activity will vitiate any duties owed by the host to the minor or anyone else. If the host gets to rely on the lie.
Yeah. Interesting. Well, good to know. Good to know.
So, Rick, my question for the two of you, and Alana as well, should we tempt fate and ask a bonus question?
I think it's time.
I think we can.
We should do it? Okay, I'm going to put up our first of 2 bonus questions.
Oh, this one's a fun one.
All right. In this instance, we have Sarah, the single mom, who's working outside the home, interestingly enough.
Yeah.
She only has Wednesdays off during the week. She sets up an appointment with the plumber for that day. Instead, the plumber shows up a day early on Tuesday to fix the sink. When he trips on the front steps, what is he? What is the status of an unexpected visitor?
Is he an invitee, a licensee, a trespasser, or none of the above? So
people
I think people will.
Yeah, they think they got this one. They all popped in quick answers here. So
yeah,
all
so
right,
let's hark back right to our very first question here, right? I'm sitting here thinking, I know that plumber's not going to get in if I'm at the office. We had a date, but that's okay.
Okay, invite trespasser 57%. In fact, that's the correct answer. He's
Good
considered
job.
a trespasser because he does not have permission to be on the property at the time and the place. So that translates. Otherwise, of course, because he was there for the mutual benefit of fixing the sink for pay, he would have been an invitee.
Otherwise.
Simply time and location makes the difference here.
They really do. It's those facts that really make the law a lot of the time.
Well, and the status here, as we talked about at the very beginning, the status of the individual, whether invitee, licensee, or trespasser, or if we could find another category, that's what really dictates the claim, the duty owed, and the chance of recovery.
Yeah. Interesting.
All right.
Well, I think we might have one more bonus question here about our most favorite coworkers. Now that we're all working from home for the most part, our pets, our lovable, cute, furry pets in particular. I know I got a pandemic puppy once our times changed, but that then begs the question, if you have a dog, if you have a puppy, who can be liable for a dog bite in Michigan? So our question to you folks is
it only the owner? Is it somebody who's keeping the dog? Is it someone who's in possession of the dog and only the owner in possession, or is it all of the above?
Yeah, I think people might be thinking about this one here. It's really interesting here.
About half the audience is confident. The other half is okay. Now they're coming in right now. So we're at 89%. Okay, here we go. Let me close this out. Interesting.
Interesting. All right. So 13% said a person has to be the owner. 25% said that the person only has to be keeping the dog. Nobody chimed in for C, but the remainder of you guys said all of the above. And that there is the correct answer, all of the above. A person, an owner, is not liable if they are not there, if their dog bites someone else. But to that same effect too, if a person is keeping a dog, so say you're dog sitting your friend's dog or something, and you were keeping the dog and you didn't take reasonable precautions, you might be liable for any potential damages that arise out of that dog bite too. So
back in the day when they were doing certain kinds of experiments at Michigan State University, they would board the dogs so they would be in a separate location. And when they did that, the person who was taking care of the dog, even though it wasn't the owner, would have been liable if that dog had bitten someone while on their premises. So,
exactly.
So this does make a difference.
It really does. It really does.
Well, I think everybody did great. They really came on strong at the end, so that was nice to see.
Yeah.
That is our last bonus question. So it is time for any general questions from our audience. If anybody would like to ask a question, feel free to use the questions window on our GoToWebinar display. I'll just give that a minute. Just type in anything you might want to ask. I haven't seen any bubble up. I think everybody's been busy responding to hitting their buzzers for all the polling questions we've been doing. But I'll give it just a second here. I do see one question here. This one reads, I am an owner of a restaurant and want to know if a patron is assaulted on premises by another patron, for example. Is my restaurant liable?
All right, so we have a patron-on-patron fight.
No.
Who is the restaurateur, the owner of the premises, liable for allowing that to happen? In fact, the restaurateur is not liable for criminal activity being conducted by a third party, in this case, the assault. For that reason, then, under those strict facts, patron on patron, in this instance, then the restaurateur, the premises owner, is not liable. The exception to that is if someone asks for the police to be called, the police have to be called within a reasonable time. Once again, we're back to the reasonable time. So there is that potential duty, but simply being responsible for criminal activity being conducted on your premises, whether it's being held up at the ATM or a fight, a robbery, those things are not the occasion of liability for the premises owner.
Yeah, and a lot of the times that's because that type of conduct is unforeseeable. It's the third party who's acting criminally that can't be foreseen by the premises owner.
And the premises owner is not obligated to act like a police department, or even for its own premises in that instance.
That was a good question.
Yeah, that's a great question. We don't have any others though, so we ended up on another high note. At this point, I think we're getting close to the top of the hour anyways. So let me just kind of wrap things up and get everybody back to their busy work days. As we always do, we send a post-webinar survey out after our events. This is going to be important about our prizes. Don't forget, I didn't forget those. Just give me a second. I'll mention that in a moment. But please take a moment to complete our survey. We do take all that feedback to heart, and we love when you suggest topics because then we know what's on your mind and we work towards presenting that material in the future. The other thing I want to mention again is that this session was recorded today and it's going to be available later, hopefully today, on our event page. So if anybody in your organization would like to view it, hopefully had a little fun, test their knowledge as well. They can find it on our event page on our website, plunketcooney.com. So have them check it out there or share the link with them. Another quick promo, shameless plug as they call it, this tort and litigation practice group sponsoring today's program maintains our litigation defenders blog. They do a nice job of getting content out there on a semi-regular basis. They do their best in their busy practices to do it. So if you'd like to check that out, it's on our website, and you can even log in or enter your email address, and you'll be given alerts whenever new content is added. So please check out Litigation Defenders. Now, the prize I mentioned, we're going to give away a $50 Visa gift card today. Now, here's the caveat. You have to complete our survey. So only the people that complete our survey today are going to be eligible to win this gift card. And Alana, I hate to say it, but Plunkett and Cooney employees and their family members are not eligible to win, so don't even try it. So please take a second and complete that survey, and you'll have a shot at winning the $50 Visa gift card. So on behalf of Rick, Alana, the entire Tort and Litigation Practice Group here at Plunkett Cooney, thanks so much for joining us today and for playing our game. We hope you had fun, and we'll see you next time. Have a great rest of the day.
Thank you, everyone.
Thank you, everyone.